Now, a very good evening to you, and thank you so much for speaking to us, Irvin. So, in dealing with an unvaccinated employee, firstly, what should be the employer's first port of call?
Good evening to you and your viewers. The directions came out on the 11th of June 2021, requiring all employers with more than 10 employees to do a risk assessment process and develop a plan around who would need to be vaccinated versus who would not need to be vaccinated. The employer then has to obviously do this risk assessment process by looking at people that have comorbidities, people that are over a certain age, and then once identified, must try and make reasonable accommodations to accommodate people who don't want to be vaccinated. And there are a number of reasons why people may not want to be vaccinated. Some have religious reasons, some may have reasons relating to their bodily integrity. And depending on those reasons and depending on the circumstances of the employer, if reasonable accommodations can't be made, an employer could very well find themselves in a position where vaccines become mandatory, and those employees who refuse to take the vaccines, schools of thought, one school says retrenchment is the way to go. My view is that it probably is a contractual incapacity issue, so it will go through an incapacity process, very much like in the situation when an employee becomes too ill to perform his job or is injured and can't perform the job for which he was employed.
Okay, so before we go into the ways in which companies can approach this, either termination or suspension of employment, I want to know what are the available alternative arrangements available for the employee who does not have to or want to be vaccinated. As you mentioned, there are myriad reasons, primary amongst which is the fact that not all we should know is available about the vaccines we're taking.
Yes, I mean, there are a number of measures that an employer should pursue. And the directive does provide an indication of this. You know, there are accommodations where you could probably have the employee work from home. There are accommodations which could involve the employee wearing a mask, an N95 grade mask. I mean, the directive refers to that specific quality of mask, an N95 grade mask. Putting up screens, just maintaining social distancing and all of that.
So I just also want to understand what is meant that is it legal if the employer says it has to terminate the employment as the employee cannot contractually perform the requirements of his or her job? So what does that mean? And talk to us against the backdrop of those developments you spoke about in retrenchment law, and can they be exploited to suit this situation, developments around COVID-19?
It's not as clear-cut as one would have liked it to have been. I mean, if you look comparatively, for example, some countries like New Zealand, and there's a case that's come out of New Zealand where there was a requirement, a legislative requirement that employees who perform border control functions or border control officer functions needed to be vaccinated. It was as clear as that. In our law, the directive does not say that that all employees can be compelled to vaccinate. It appears to anticipate that as being a prospect and requiring employers to have a vaccination plan. So you really have to jump through all the hoops of showing it is a last resort where you can actually say to employees, it's going to be mandatory.
I mean, one of them, which you mentioned, is that one school of thought says dismissal must be a way of retrenchment, while another view is to treat a case where an employee has become incapacitated to do a specific job due to a disability sustained. Isn't that prejudicial? Because should you choose to go into another line of work, should your papers then say you are pretty much incapacitated, does that not prejudice you in some way?
Well, I don't think it would prejudice you if you're able to go into another line of work where accommodations can be made and reasonable adaptations can be put in place to accommodate your refusal to vaccinate. As I said, I don't, with respect, believe that retrenchment is the right route to go. It's probably going to be treated almost as as an incapacity, unable to fulfill your contract of employment.
And you said there are other two retrenchment law developments to take note of here in South Africa.
I beg your pardon, I didn't get that.
You have said that there are other two retrenchment law developments to take note of, where in a South African court, for instance, it found that due to the impact of COVID-19, a company's retrenchment consultation and facilitation process did not need to be suspended until lockdown levels eased.
Oh yes, that was a development in terms of how one conducts the facilitation process. I mean, that process, when it came out with the amendments to the Labour Relations Act, by its nature and by design, envisaged a face-to-face consultation process facilitated through the agency of the CCMA. In that particular case involving Forward, SA Breweries, the retrenchment consultation process, large-scale retrenchment process, had actually started in January of 2020, and then we had the hard lockdowns announced by our president. And at that stage, they were in a catch-22 situation. They could either, stop that consultation until lockdown levels had eased, or they could forge ahead using social media. They chose to forge ahead. The union was not interested and didn't want to participate in a virtual platform type consultation process. And the court basically found that the employer would go ahead and proceed with its retrenchment consultations.
And the other one you mentioned had to do with the retirement age and continuity of service with regards to,
I mean, the Basic Conditions of Employment Act is very clear that unless you've had broken service more than a year, you are entitled to have past service taken into account. In this case, what had happened is the gentleman had reached 65 years of age, had not gone on to formal retirement, but had been paid certain retirement benefits, continued as though, nothing had changed. And then at a particular point in time, his employer decided to retrench, and he accepted a voluntary retrenchment package. But they only calculated from the date after his retirement, and the court basically said that was unfair. He was entitled to have his previous service taken into account in reckoning what his severance package would have been, because at law is 1 week for every completed year of service.
Thank you for your time and insights. Irvin Lawrence-Employment expert at law firm ENSAfrica. It's time now for your sports news.